that would certainly be, it's not just that it was reasonable, right? Because a jury could conclude that their belief was reasonable, although the first jury didn't, but a jury could. But still convict them if it wasn't based on an official statement, right? A jury might decide, look, especially if the instruction said a reasonable Christian Scientist or a reasonable person with those religious beliefs. Because then the jury might say, well, yeah, a reasonable person would think that this statement was a correct statement of the law and they were just mistaken. But that's not good enough. It has to be not only reasonable, but reasonable and based upon a specific category of information.
Well, didn't she act under the advice of the lawyer that was giving the...
Good. And again, on a scale of 0 to 10, what is the value of relying on a private attorney that you hire versus relying on an official statement from a government official who has the responsibility and the authority to interpret that law?
I want to say negative 43 just because it's the number that's fun.
That's good. Now, I wouldn't go that far. I would say like negative 20. It's better than relying on the publication of your church. Because at least, and there's one decision, it's mentioned in your notes, it's from Delaware. I can't remember the name of the case, but it's in your notes, in the book, and it involved bigamy, right? Where the guy had gone to a private lawyer and said, oh yes, your divorce is valid, you can go ahead and get remarried. And in that one case, the Delaware Supreme Court said he couldn't be convicted, right? He could rely on the private attorney. Everywhere else and in every other context, no good. And the reason for that is you don't want to give really bad incentives to lawyers to give their clients really bad advice. Right? If you empower lawyers to basically be their own private attorney general, and their advice ends up immunizing their clients, that would lead to really bad consequences. Bad lawyers, corrupt lawyers, and there are those out there, hopefully none are sitting in this room, no future bad lawyers, would say, oh, sure, I'll write you an opinion letter that says you can go ahead and engage in insider trading, or that it's perfectly okay to kill your spouse for the insurance money. No court in the world could convict you of that because, you deserve the money. You don't want, and hopefully attorneys general would not issue such opinion letters, but private lawyers, for the right fees and for the right circumstances, might. I exaggerate the kinds of advice they might give, but we don't want to give private lawyers authorize them to basically nullify the criminal law. Right? So give your clients good advice. All right, any other questions about Twitchell? Yeah.
Why do we think that the Supreme Court suggested that it should be thrown out? Because it seems to me like the statute doesn't line up with the crime anyway. Like it underlies negligence as opposed to recklessness.
Well, I think there's two possibilities. One is the opinion of the Attorney General. That the fact that the Attorney General had issued this opinion and then they turned around and prosecuted these folks struck the court as quite wrong. That's one possibility. The other possibility is the court was more broadly sympathetic to these parents which I personally would not be. I'll just say I personally would not be, but some others might be. That if the judges thought, these were grieving parents, they made a terrible choice, tragic consequences, but they certainly didn't intend to kill their child, and that there's no need for the criminal law to be imposed upon parents who are already paying such terrible consequences for their decisions. And we will see another case later in the semester that personally I think better captures that idea than this one does, but that could have also been, at least in some of the justices of the Massachusetts Supreme Court, what was underlying their push to the prosecutors to let this go. But it might have been the first one. It might have just been the first one. Okay? All right. Everyone ready to talk about causation? This is our next unit, the significance of harm, of which the first part is causation. And your authors of your casebook, if you look on page 289, asks whether or not conditioning liability or culpability on causing a result makes sense. Why punish causation? Or why should we ever condition punishment on the causing of harm? And we have already addressed this, a little bit. We have touched on it just a little bit when we asked the question, well, if two people engage in the exact same act with the exact same mental state, let's say intent to kill, and take the same action, they both pull a trigger on a gun, aren't they exactly as blameworthy and exactly as dangerous to society? Remember the question I asked you about the soldier on the battlefield intending to kill her commanding officer, who instead, one of them does, and the other one misses and instead kills the enemy. Kills an enemy soldier, right? Exact same action with the exact same intent. They both seem equally dangerous to society, blameworthy for their conduct. But punishment is going to be hugely different in the two cases, or the consequences of their actions. And the authors ask on 290, do we make criminal liability into a lottery? And I phrased it earlier in the semester as dumb luck. Well, now we get to dumb luck. Okay, so we'll see the extent to which we think dumb luck, when causation is an element of criminality, when courts say, aha, you caused this, therefore you can be convicted and punished. You didn't cause this, so you can't, whether that makes sense. And what are the rules? What are the rules for causation? That's our first, obviously, our first step. And that leads us to Regina against Martin Dios. Okay. Tell me what happened here. Tell me what happened here. There.
So on Friday night there was a dance at a community center. There were 7 youths, one of which was RM, which is the boy who dies in this incident.
And who else was there?
And
Who triggers this whole cascade of events?
the BT, the boyfriend.
Well, BT, but why did BT get mad?
Because they were dancing with his girl.
Who was?
SK.
SK was caused all this fuss because he danced near 2 girls, and in doing so he was cocky and showing off. Okay? And this got BT really mad. Why are you dancing with or near or around my girlfriend? Okay? So what happens as a result of this?
So basically the boyfriend and his group of 5, and then there's the group of 7. The group of 5 follow the group of 7 out, and they're being like threatening and abusive and all that. And then they start to throw stones and bricks.
Bricks, you say?
Yeah. And then
Hold on.
The word of the day is brick.
The word is brick.
oh yay!
Oh, you didn't see that coming?
No,
Sorry, I was on the phone with draw.
That's okay. That's okay. So the group of 5 follows their threats at SK and the rest of the group of 7, and then they close in on him. And one of them, and who do we know for sure is throwing stones and bricks?
MD.
Or Martin Dios. They say MD, but it's Martin Dios. Okay? And one hit a member of that group on the head. Who was that?
PS. Or, yeah. There's so many abbreviations. MD hit PS, which is one of the 7 on the back of the head. And then he took off his jacket and they started fighting.
And he hits BT, and a huge brawl ensues.
Yeah.
Okay? What is this?
West Side Story?
It is West Side Story! Right? Dance at the gym, 2 rival gangs, dancing with the wrong person, and a huge tragedy ensues and a huge brawl breaks out. Okay? This is West Side Story without the Sondheim Bernstein music. Okay? If you didn't know that, or if you've never seen West Side Story, I don't want to know you. But that's what this is. This is the British version of West Side Story. It's uncanny. It's uncanny. Okay? Okay. Huge fight breaks out, right, Ms. Nairn? Huge fight breaks out. And what does Martin Dios do? Or what do we know happens at the end of this fight? How does it end?
So it only didn't last more than a minute, and because RM was seen lying in the road with a severe head injury and he was bleeding out, so the 5 fled and.
So how is Martin Dios, this brawl, they're all engaged in it. How is Martin Dios to blame for this?
Because he, and I think he admitted to it too, but he admitted that he had thrown a brick at,
He threw a brick that hit RN in the head,
yes.
right? And according to what he told police, someone threw a punch at me, he ran away, he was hit in the back by a brick, so he picked up the brick and started towards the one he thought had chucked it at him, and he threw it and it hit RM, and he said he misjudged the distance. RM dies 9 days later, okay? None of the 7 who were the chasees are charged with anything. The others in MD's group, the group of 5, were charged with and pled guilty to unlawful assembly. So everyone else pretty much walks almost free, right? Unlawful assembly, it's a crime, but it's pretty minor.
Yeah.
Who's the one person who gets very different results in terms of their charges from the criminal justice system? MD, and he's charged with?
He is charged with murder and grievous bodily harm.
Now this seems like a pretty open and shut case. You hit somebody in the head with a brick, which he confesses to, acknowledges he did, and they die. You're charged with murder. I think you're in big trouble. What's the problem with the prosecution's case?
RM received 2 or more separate blows, so they don't know that it was the act that MD did that actually caused RM's death.
So we've got the injury caused by MD and another injury behind the right ear for which we have no idea what caused it. Whether it was somebody else hit him, whether it was when he fell to the ground, etc. Okay? What did the medical examiner say about the cause of death? This is really important to follow the bouncing details of this, because the specifics of what the medical examiner says make a huge difference in Martin Dios's fate.
I think you're talking the last thing he said about that there was a reasonable and sensible possibility that the.
Well, what was the cause? The medical examiner does say what the cause of death was. What is the cause? Let's start with that. What was the cause of death?
Cerebral contusion due to fractured skull.
So far, so good for the prosecution, because Martin Dios, inflicted a cerebral contusion and fractured his skull. Okay, what about the comparison between the 2 wounds, or the relative contribution of the 2 wounds?
He says there is no evidence as to whether they caused the same, or they were caused by the same or different objects.
And if you're representing Martin Dios, what do you make of that point? That there was no evidence as to whether or not the 2 separate wounds were caused by the same object?
There could have been another, like, someone else could have thrown something, or he could have walked into traffic, so there could have been another act not done.
And when the medical examiner says the second other wound might have been caused by some other object, some other rock, some other blow, what are you going to say that means for your case, and or alternatively for the prosecution's case?
That second act was what caused his death.
Well, you don't have to go that far. You don't have to go that far.
That
It could have caused his death?
It could have caused his death, and
That's That it's an alternate cause?
It's an alternate cause. An alternate, the important part of alternate there is not from Martin Dios. You're going to say, look, since we have no evidence as to what was the cause of the second wound, there, you can't say beyond a reasonable doubt that it was my client. Okay, so the fact that the medical examiner says there is simply no evidence of what inflicted the second wound is very, very valuable for Martin Dios. Okay? And what about the relative relationship between each of the wounds and RM's death?
Like the only piece of evidence that they had.
No.
There's no way of knowing which came first.
A, there's no way of knowing which came first. Either one would probably have been fatal. And there was also a reasonable possibility that RM might have recovered from the first injury, whichever it was. What are you going to make of that? It's Ms. Walls, right?
Yeah.
Ms. Walls, what are you going to make of that representing Martin Dios? That the pathologist says, we don't know which came first. Either one might have been fatal, perhaps even standing alone, but either one, if it had been the only one, whichever came first, he might have recovered from that one.
That Martin Dios could have struck him first, and if nothing else had happened, he wouldn't have died. He would have recovered from it.
It took, in other words, it took both. My client's contribution, my client's act was not the cause of death, certainly not a sufficient, standing alone, cause of death. So what, somebody else, what did the trial judge do with all this mess?
The trial judge upheld his submission of defense.
Which is, what was the submission of the defense?
That the pathologist's evidence stated it was a reasonable and sensible possibility that the injury behind the ear caused the death, and no evidence that MD was responsible.
And what did that mean ultimately for the case?
That they couldn't prove beyond a reasonable doubt that he caused the
And
death.
good, and so the trial judge says, we're not even going to send this to the jury, because there is not proof beyond a reasonable doubt that he was the cause of death. And the defense makes this argument on two grounds. First, the pathologist's testimony that the ear injury might have caused the death, and the lack of evidence that Dios was responsible for the ear injury. And second, in turn, no evidence that the injury Martin Dios did inflict beyond a reasonable doubt caused the death by itself. Okay? So let's look at these in sequence. What if Martin Dios's injury, when he inflicted, came first? How would you argue to the court that in that event, Martin Dios could not be shown beyond a reasonable doubt, no rational jury could find beyond a reasonable doubt that causation existed?
The pathologist said that.
A little louder.
The pathologist said that the first injury he could have recovered from.
Good. Pathologist testified RM could have recovered from the first injury, which makes second injury a necessary cause. It was necessary to the outcome. Right? If he in fact could have recovered from the first injury, and the pathologist said he might have been able to. Didn't say he absolutely could have, but that's where the burden of proof makes a huge difference. Right? As long as this was a possibility, it's not beyond a reasonable doubt that Martin Dios's actions caused the death, because in that event, the second injury would be a necessary cause of RM's death. Okay? Therefore, you can't convict him beyond a reasonable doubt. You might be able to say he might have caused the death, because it's also possible that he wouldn't have recovered from the first injury. But possible isn't enough for the prosecution. Okay? Second, what if Martin Dios's injury came? These are the only two possibilities. We got two wounds to play with. It had to come first or second. Okay? So what if Martin Dios's injury came second? What would you say there?
That the first injury could have been the approximate cause of the death.
Right? Pathologist also testified. He testified that he might have recovered from the first injury, which that part of the testimony would be the prosecution would use in the event the injury came second. But he also testifies the first injury, or either of the two, could have been sufficient. And here I'm putting the both necessary over here and sufficient to sort of highlight this idea of necessary and sufficient causes. And if the first injury was sufficient to cause death, then MD's blow was irrelevant. And you can't say MD caused RM's death, or at least not beyond a reasonable doubt. So the fact that there was uncertainty means, and uncertainty is like the death knell of prosecutions, right? The fact that there was uncertainty means you can't show causation. Everyone see this? What if we had been able to show that Martin Dios's blow to RM was a cause of RM's death? Would that be enough?
No, it wouldn't be enough, because if you said a cause, not the cause.
Why not?
Well, you said that there was more than one injury. How do you know that that injury was the final blow needed to kill?
Well, one of the things we are going to talk about as we go through causation is this idea of multiple causes. And I'm going to posit to you right now that everything that ever has happened in the world, everything that has happened to you in your lives, everything that has ever happened to anyone else, everything that happens has multiple causes. So if the criminal law was going to punish all criminal harms by looking for all of the things that cause them, we're going to be awfully busy prosecuting. Okay? So I have an example of this if you don't believe me. I have an example for you. Who caused the death of Abraham Lincoln? Anyone?
John
Well,
Wilkes Booth.
Somebody, who said that? John Wilkes Booth. Okay, anyone else?
I was gonna say Sergeant Rathbone also wasn't there, so he could have stopped it.
Sergeant Rathbone. You want to explain to anyone who Sergeant Rathbone was?
He was supposed to accompany Lincoln to the play that night, and because he didn't, he was
The
stopped.
door was unguarded. The door to the presidential box. Anyone else?
Going down this route, do we want to say Booth's parents?
You laugh. Why? Why?
Because if they hadn't had him, it wouldn't happen.
Or we can even take it further back. How about the grandparents? And that's actually where I want to go. If all we're asking for is but for, that's the term in law, but for causation, that is, X wouldn't have happened but for Y, then anything can be said to be the cause of anything else as long as it's in that chain. And we think of chains of causation. The links can go as far back as you want to go. Okay? So, if they're still alive in 1865, sure, let's prosecute John Wilkes Booth's grandparents. Because if they hadn't had their kids who had their kids, Abraham Lincoln would have not been shot at Ford's Theater. Now, how many of you would have wanted to prosecute John Wilkes Booth's grandparents? Why not? Do you not believe in causation?
Well, I mean, there's more than just that. There was also some sort of an underlying conspiracy to assassinate Lincoln in the first place.
So what? I'll prosecute all of them. I'm not saying only the grandparents. We'll round them all up. Anyone who we can show caused this, we're going to prosecute them. And sure, get the conspirators too. Get Dr. Mudd. I'm good with that. Why not?
Because they weren't the actor.
They weren't, so only the actor. Like, so the co-conspirators, we're going to let them off. Well, that seems shaky.
In a way, they're kind of not like the direct Charles Davis.
Good. What we want, right, if we have going to think of this as a chain, right? That's not a bad chain. We're going to think of this as a chain. In the chain of causation. Get used to that phrase. You're going to hear it here. You can hear it in torts until you're sick of it. If we're going to think of this chain of causation, and anything, you don't even get on this chain unless you're at least a but-for cause. So the first thing we're going to look for is but-for causes. They have to at least be that. That's like the minimal threshold to even get in the game. But that's not, it clearly can't be enough by itself. Right? So we've gone through the door, we've at least said, yeah, it was but for. We can start with that. What we want is some place to draw the line between the but for causes that we're going to say, no, those don't count for criminal culpability. Those are too remote. And what we call direct or proximate causes. That is our holy grail. What we are looking for is how the law defines the threat. All proximate causes are but for, but not all but for are proximate. So what we're looking for is what rules, what tests, what factors make a cause not just but for, but proximate. Those are the ones that we can use, that we can prosecute over. Okay? So we're not going to prosecute Abe Lincoln's grandparents, John Wilkes Booth's grandparents, but we might prosecute John Wilkes Booth and his conspirators. Okay? Okay. Any other questions about this? And I don't mean to, I just want to introduce this for now. We will get into what those factors are as we move through these cases. What makes a cause actually proximate. So here's the place to at least start the consideration of that. All right, let's talk about Benji. There was a fatal railroad accident. No one likes to hear about those. And this is at Staplehurst, 2 miles towards London from the Headcorn station. How did this happen? How did this awful thing happen?
So, the defendant was a foreman of a crew that was sent to replace the tracks. had a book, that told him when the train would be coming in and out of the schedule. This is supposed to aid him to when, different sections should be repaired.
Because you don't want to pick up the tracks to replace them when a train is due.
Right.
Because that's bound to lead to not such good results. So you need to know when the trains are due, right? And make sure one is not coming during the time you're going to need to get the job done, okay?
So, the defendant misread the book. He looked at Saturday instead of Friday and decided to take up a part of the tracks that was needed less than a half an hour before a train was due.
So that's on Friday. On Friday, when was the train due?
3:15.
So here's our sequence. On Friday, train due at 3:15 to come through. And when does he order the tracks to be taken up?
He orders it after the last train passed at 2:50.
So prior train, 2:50. So between 2:50 and 3:15, Benji orders tracks lifted. Okay? And he does this because he read the date for Saturday. And when would the next train have been due after 2:50 if it was Saturday?
I believe it was 5:20.
That's right, 5:20. And that would have been plenty of time to get the work done if he had, if this had been Saturday and he had ordered it around 3, let's say 2:55, he would have had plenty of time to get it done, have it be safe before 5:20, but he didn't have anything close to enough time before 3:15. So reading the wrong date was a really bad thing, okay? So what then happened, or to put it another way, what didn't happen in addition before the train got there?
So, it is a rule that there must be a flagger, 1,000 yards out from where the work is going to be done.
And in the direction the train is coming from.
Right.
Right?
And, the flagger should be seen by the train by 500 yards, giving a total of 1,500 yards or nearly a mile for the train to stop before the tracks ran out.
And
So
what happened instead?
The person that Benji sent only went like 500 feet, and so the train couldn't stop in time.
And so when he saw the train coming 500 yards in the distance, it was way too late, okay? And so what happened?
The train derailed and killed a few.
And as the court puts it, I love this language, the catastrophe ensued in which many lives were lost, okay? So what did Benji's lawyer argue in what seems like what did he argue?
He argued that the death, or the conviction should be dependent on whether the death was mainly caused by the defendant.
More simply,
He was the sole cause.
is that what Benji's lawyer argued? Would you want to argue that if you were Benji's lawyer? Oh yeah, my client was the sole cause of their death.
Pretty much he's trying to say that the other causes of the death should be considered.
He did not cause the death, and what's his basis for that? Because, I mean, look, Benji did this. Isn't it true that without Benji doing this, the train would not have derailed? So don't we have but-for causation?
But he also says that because the flagger didn't do what they were ordered and the train conductor didn't use reasonable care to stop as well, they have also had causation.
He says, look, even with the mistake that Benji made, the accident could not have happened without somebody else's mistake. So my client's conduct was not a sufficient cause standing alone because the flagger should have prevented it. If the flagger had been where the flagger was supposed to be and caught it in time, and by the way, who else screwed up?
Didn't they say that the conductor, like, didn't realize it in time or something?
The conductor also screwed up, according to Benji's lawyer, and that was also a reason why, that even given the tracks, the accident shouldn't have happened but for other people's mistakes. The conductor should have hit the brakes more quickly. Okay? Doesn't this sound a lot like Martin Dios?
Yeah.
Right? Martin Dios, he didn't alone cause the deaths. Here Benji is saying my client didn't alone cause the deaths. The actions of others did as well. The actions of others, whoever inflicted the other injury. And so it can't be said that Benji's actions alone would have resulted in the deaths of the train accident without the contributing actions of others. So, Ms. Cull, same result?
No. He was found guilty.
No. So wait a minute. Seems like the same setup and we get a different result? Does that have you already wishing you'd never come to law school when you see stuff like this?
A little bit.
Just a little. Okay, I'll take that. When we don't get the same result, we got to ask, well, what was different? Now, sometimes the answer is going to be nothing's different. These courts just reach different results. And that gives you the opportunity to say, here's the case I would use to argue this, how it should come out, even though the setup is the same if I was representing the prosecution. And here's the case I would use if I was representing the defense, because courts just disagree, apply the law differently, think the principles should be different. Is there a difference here that you can use to actually distinguish these cases?
I think the difference is that the defendant caused the situation, so if he hadn't have misread the plans, he wouldn't have had a need to send the flagger out, and at that time, the conductor wouldn't have needed to stop and therefore cause the whole situation.
Excellent, excellent. The difference, if you're going to buy one, right? And if I were lawyer for Benji, I would certainly want to rely if it had existed at the time. It didn't. But if it had Martin Dios, it came a century later. But if it had Martin Dios, I certainly want to rely on it. But if there is a difference in between them, it's that, remember one of the things we could say in Martin Dios, that we could not even say that Martin Dios